Line 116, if loan approval has been obtained or deemed to have been obtained, and the buyer fails to close the contract, then the deposit shall be paid to the seller, unless failure to close is due to these next three things. Number one, seller default. Yeah, if the seller breaches the contract and they default, the buyer's deposit is not in jeopardy. But again, you have to prove seller default. The reason for closing has to be the seller's fault, not the buyer's fault. Number two, property-related conditions of the loan approval have not been met, except when such conditions are waived by other provisions in this contract. Let's say we find out that the roof needs to be repaired and there's loan approval, but the seller has to repair the roof and the seller doesn't do it. Well, the loan gets denied, but that's not the buyer's fault. There's a property-related condition and the loan approval is now rescinded because of that. That's also an example that's partly within the seller control. What if the property is destroyed? Now, all of a sudden, there's property-related conditions where the loan approval that was given previously now has to be rescinded. Or lenders have used this situation where there is a problem with the association, whether it is a situation with zoning or a situation where the association has weird language in their documents about whose responsibility certain things are, or if there's a lawsuit against the association. Lenders will argue that that is a property-related condition. Depending on what it is, from a legal standpoint, I may agree with them, I may disagree with them. There's no case that actually, no court case that actually lays out what a property-related condition is. I've always thought that a property-related condition has to be something related to the physical property itself, but I do have lenders that argue a lot, especially with associations, that it could have to do with the makeup of an association, whether it's their documents or whether it's something to do with a common element to the association. So they'll make that argument a lot. The third one on here that comes up most often is appraisal of the property obtained by buyer's lender is insufficient to meet the terms of the loan approval. So there's a built-in appraisal contingency within the contract that is separate from the appraisal contingency rider that we have. In this situation, the buyer has loan approval, but the loan approval is conditioned upon the property appraising at the purchase price. If they have loan approval and the appraisal is done well after loan approval and the property doesn't appraise, and then the buyer loses their loan approval, this section is saying that they can back out of the contract and get their deposit back. So, especially in this situation, if you in this market where the seller, where it's a real seller's market, there's offers above asking price, there's appraisal contingencies. From the listing side, you want to get rid of this section in the contract because you don't want loan approval to go through, everything is going great, and then the lender took so long to order the appraisal that the appraisal comes in the week before closing, and then all of a sudden the buyer loses loan approval, and then you have to go back to your seller and say, well, actually the contract says they get their money back.